We'll go to questions. Mr. Sassy, let me ask you this, because you threw a bunch of statistics at us, but I was just looking at the state of California alone, and it seems to me, if I remember correctly, in July of 2008, Anthem Blue Cross, which is a subsidiary of WellPoint, paid a $10,000 fine and had to reinstate 1,770 rescinded policies. And then in February of 2009, once again, California, Anthem Blue Cross, again, one of your subsidiaries, had to pay a $15 million fine and reinstate over 2,300 rescinded policies. And then another settlement, $5 million, and another 450. So it seems like in the last year you've had to reverse 4,500 rescissions and pay a fine of $30 million just in one state. Is that true?
I don't believe the numbers are exactly accurate, but the premise is accurate. The issue of rescission first surfaced in the media, particularly in California, I believe, in 06 and 07. And shortly thereafter, one of our regulators initiated an audit, issued audit findings. We disputed the majority of those findings, and our response is appended to that audit report. The regulator subsequently did change.
Well, according to California Department of Management and Health, in July of 2008, last year, July 17, 2008, you entered in an agreement with California to
yes,
over 1,700 people in a $10 million fine. And in February 2009, California Department of Insurance also put out a release indicating that you paid a $15 million fine and had to reinstate 2,300 people. So that's, according to my math, that's about just over 4,000 and $25 million in fines, right?
Yeah, I think there wasn't a $15 million fine to the Department of Insurance. Irregardless of that, companies enter into settlement.
Let me ask you this:
or individuals enter into settlement agreements for a variety.
Let me ask
of reasons.
you this, and I'll ask all three of you. Why don't you just vet these policies before you ever collect a premium? Why don't you just go through these policies and make sure there's no problems with it before you insure the people? Only one state requires you to do that, and that's Connecticut, right?
Chairman, we do investigate the applicants. We have very rigorous underwriting requirements. As we review an applicant's application, we rely on the applicants to be truthful in completing. And our experience has shown that over 99% of applicants are truthful in completing their applications.
So when do you do the
rely on that.
When do you do the investigation then?
Well,
why are we getting these post-underwriting going on? Why does that occur?
Well, I would contend that we don't participate in post-claim underwriting.
Really? Well, let me ask you this.
If there is a situation where either a pharmacy claim was received or a pre-authorization for a hospital stay is received or a claim that's received that would hit either a specific diagnosis that could lead to potential fraud, that would trigger an underwriter to investigate.
Well, let me ask you this. In the book there, right there, and I believe it's tab number 11, that's our document. You gave us, WellPoint provided the committee with a list of conditions that automatically lead to an investigation post-underwriting, okay? And for WellPoint, the list of conditions that trigger rescission investigation includes diseases ranging from heart disease and high blood pressure to diabetes and even pregnancy. So what do these conditions have in common that would cause you to investigate patients with these conditions for a possible rescission? You have 1,400 different conditions which will trigger, according to your documents, which will trigger an investigation.
Chairman, an investigation does not mean that a rescission actually occurs. For example, in 2008, there were over 16,000 investigations triggered. 92% of those were dismissed, and no action was taken.
Right, but why do you have 14 different conditions which trigger an investigation? What's the common theme amongst these 1,400 that would trigger an investigation?
I would say there's no common theme other than these are conditions that had the applicant disclosed their knowledge of a condition at the time of initial underwriting, we may have taken a different underwriting action. And so that is what the investigation really is about, is to determine, did the applicant have the condition? Did they know about the condition?
Well, I thought you said you did pre-screening before. You screened them before.
We do, but in many of these
Well,
applications,
then why would you have to go back? If you screened them before and there wasn't a problem, then why would you have a list of 1,400 different conditions that triggers an investigation? If you pre-screen, if your pre-screening's good, you wouldn't need a list of 1,400, would you?
but unfortunately, there are those among us that are not truthful in completing their application.
So in 1,400 different areas, they lie? The applicants lie? Or is it really a cost issue? These are
Yeah,
1,400
rescission is
expensive
not-
areas, aren't they?
Yeah, rescission is not about cost. A pharmacy claim that's $20 could trigger something.
Sure, if it's for a certain condition, right? Heart disease?
No, not necessarily.
Okay. All right. My time's up. Mr. Walden?
Thank you, Mr. Chairman. I'd just like to ask each of the companies present, is it your company's policy to deny coverage to any applicant that discloses that he or she has had previous policies rescinded? You heard some of the witnesses today say, look, once I get rescinded, no company's going to write me again on an individual policy. Is that correct, Mr. Sassy?
I am personally unaware of that policy.
Mr. Collins?
Sir, we do have that question on our application, but I am not aware as to whether or not what the underwriting guidelines are. So we ask if you've been rescinded or declined by another carrier.
But you don't know what happens with that information?
No, sir. I imagine it triggers an investigation, but I don't know if there's an underwriting policy that's directly linked to that. That's a black and white policy.
Mr. Ham?
Yes, we would not provide coverage in that situation.
So do you ever look to see if a rescission, the circumstances around another company's rescinding of a policy before you just, I mean, if they check the box says, yeah, I was rescinded in the past.
Our
You don't
underwriting
look-
guidelines are that we would not issue that policy.
Wow. Mr. Collins, is that your underwriting? Can somebody tell you from your, if that's your underwriting policy too?
I don't know, sir, but I'd be happy to get back to you with an answer on that.
And Mr. Sassy, is that your company's policy?
Again, I am not aware of the policy. I would be happy to research it and provide a response for the record.
You obviously sat here and heard the testimony of the prior witnesses. And some of the information we've seen indicates there are mistakes made in rescinding policies, at least from our standpoint, and I think you've settled some cases and all along those lines. After hearing that testimony and all, do you think it should be your company's policy to just not issue a private insurance policy to somebody who'd been rescinded by another company? Should that be the policy of your company?
Well, as I stated for the record, I'm not aware that that is a company policy.
And I understand, I stipulate that.
I think that is
Should
a
it be?
factor that should be considered.
But I'm hearing, at least from Mr. Ham, that it is your company's policy, that if they were rescinded by another company, it's a no-go coming to your company. That's correct, right? I heard you correctly. Mr. Collins, do you think that should be, once you find out whether it is or not, do you think it ought to be?
Well, sir, I think we should investigate the circumstances.
Well, I do too. I mean, if somebody did lie on a prior form, that's one thing. If they are truthful in your form, though, should that, because they made a mistake in the past, should they never be forgiven? I mean, should they never have a shot at health insurance again?
Well,
I mean,
sir,
let's take Ms. Horton's case. You heard her situation. You heard her fear. So she'll never get offered coverage again. Is that right?
I agree. It should be something that should be investigated and considered.
Right. Most of your company policies approve a decision to rescind if an applicant made any material misrepresentations or omissions in the application. I understand that. How does your company ensure the applicant was aware of the condition or notation found in his or her medical records? We've had some testimony along those lines and we've seen some in some of the files where they say, my doctor never told me that, and we have letters from physicians who say, that's correct, I make notes all the time in the medical files, I didn't tell the patient that. Where's the balance here? Mr. Ham?
We have a very fair and thorough process of determining if there was a material misrepresentation.
Mm-hmm.
A process involves several layers review and a review panel, including a medical doctor. And in that process, we gather all the available information with respect to a person's use of medical services, including medical records, as well as the information on their application. And we'll do a detailed research and look at each situation based on the facts, make a determination whether there was a material misrepresentation when the policy was underwritten.
So do you look at the case files? Do you look at the medical records? Do you communicate directly with the physician?
We will communicate when it is necessary.
Well, but to determine the material misrepresentation, what happens in a case where the physician says, I never told the patient that?
It's difficult to speak of hypothetical situations.
It
depends on the facts of each time. But I can tell you that we would not rescind a policy if the applicant was not aware of the condition.
Mr. Collins?
Sir, we afford the customer the right to appeal, and we accept statements and information from the customer and their physicians with regards to the circumstances of the rescission, and we would take that into account. And I think it's a fair-minded people would say that if a individual did not know of a condition that was noted in the medical record, then that would not be grounds for a rescission normally.
Mr. Sassy?
We also have a thorough process. When we initiate a rescission investigation, we do reach out to the member and share with them the information that we do have and ask them to provide us with any comments or other relevant information. And all of that information is used in making a recommendation, and all that information is provided to our application review committee that actually makes the rescission decision. We would not rescind a member that we could determine did not know of their condition.
And Mr. Ham's company, I know, a week and a half or 2 weeks ago, started this third-party independent review opportunity, correct?
That is correct. We recently implemented that.
And I commend you for that. I think that's a good move. Mr. Collins, is your company, Mr. Sassy, do you have a similar sort of independent review panel that an insured could go to and make the case?
No, sir, we do not have an independent review panel.
Do you plan to go that route? Is that something you're thinking about? Or
It's under consideration, but we haven't made that decision, sir.
Mr. Sassy?
Congressman, we were the first insurer to implement an independent third-party review, and we implemented that in July of 2008.
Okay, so last July. All right, my time's expired. Thank you, Mr. Chairman.
Well, thanks. On this third-party review, that was because California made you do it, right? Your
No,
third-party.
absolutely not. It was a
Really?
requirement.
Okay. Because in your opening statement, all you said you had announced robust consumer protections. So I wanted to know what's the difference between announcing and implementation. I want to see if you had implemented those robust consumer protections. Have you implemented those robust consumer protections you mentioned in your opening statement?
Yes, absolutely.
Okay.
In my written testimony to the subcommittee, we've outlined 10 recommendations. We have implemented 8 of those 10 recommendations.
So 8 of the 10 are there. Okay.
Yep.
Okay. Mr. Ham, you said you would not reject or rescind a contract for a policyholder if the policyholder had no knowledge of it. Well, that's the Raditz case. That was our last case. That was Otto Raditz. He didn't have any idea he had gallstones and an aneurysm, and your company rejected him.
Mr. Chairman, I would really like to comment on that case.
Sure.
However, due to privacy concerns, I'm not able to. But I can tell you that in situations when we uncover that the individual was not aware of the condition, we would not go forward with a rescission.
So, but do all your clients then or policyholders have to get a hold of the Attorney General of their state to get it done? I mean, that's what Raditz had to do, and you denied them twice.
We have a very detailed appeals process. In fact, after the 3 levels review and the entire committee voting for a rescission, we notify the customer. We give them 15 days. We delay the rescission, giving them an opportunity to respond back to us with additional information. And when it does come in, we have a different underwriter look at the appeal, and they may appeal as many times as they would like.
Raditz only had 2 or 3 weeks to get his stem cell.
We go through the process as fast as possible.
And I apologize, Gimster, to you. I didn't see you there. You got to change the color of your suit. I'll go to you for questions, please.
Going to have to remind the chairman, Georgia was the 4th state admitted to this union when Michigan was still Indian territory. We don't need to be overlooked. Thank you, though. We didn't win that argument, though. Normally, we're confronted here with the question of, do we need new federal legislation? And the gentlemen from the insurance industry have all uniformly told us that if we will pass a federal mandate of having everybody mandatorily in the insurance pool, that all of these problems will go away. What I find interesting, Ms. Politz, is that you brought up a question that nobody has seemed to answer. In your testimony, you point out that in 1996, the HIPAA provisions required that in individual health insurance policies, that not only is it a guarantee of renewability, but you say continuation in force. Now, do you interpret that phrase to mean the non-cancelability that we've been talking about here?
Yes, sir.
And if so, if that is what the law that has been in place since 1996 means, why are we having this discussion?
Well, I'm not sure if I can answer that second question, but I think I should say I am not an attorney. I just read English, and the words say continue in force. And the only exceptions that among the ones we're talking about today are fraud. And that is inconsistent with what these other kind of post-claims underwriting guidelines that are or provisions that are in state law provide for, which say that fraud is the only defense or the only reason for canceling after a 2-year period. So that essentially new policyholders can't ever quite be sure if they're really covered. The insurance industry kind of gets a do-over and gets to look again, and any material omission, whether material just means it matters. It doesn't mean that it was fraudulent. It just means that it matters to the insurance industry. That can become the basis for challenging coverage. Sometimes coverage is rescinded. Sometimes it's terminated going forward. Some insurers won't rescind a policy because they don't want to get into an argument with doctors and hospitals who may already have been paid to try to get that money back, and so they'll just cancel the policy going forward, and sometimes a pre-ex will be imposed. But with respect to cancellation and rescission, I think the Congress spoke on this in 1996, and
none of the 5 exceptions to that fit the discussions here unless it is elevated to the level of fraud.
That is correct.
And I would ask the entire panel, are you aware of any court interpretation or any question that has ever been raised as to the applicability of this section 2742A of the Public Health Service Act as it relates to the issue we're talking about here today, as to whether or not it in fact does preclude cancellation for whatever we might call it, whether we call it post-review underwriting?
Congressman, may I speak to that?
Yes.
This is a legal issue, but I don't believe that rescission is considered a non-renewal.
Well, but it doesn't just stop when it says shall renew. It says or continue in force. I guess if you read that phrase or continue in force to mean the same as renew, then it would actually be a redundant phrase, which the law generally does not favor redundancy. Has this ever been challenged, Ms. Pollitt? Anybody know that it's ever been raised before?
I have no knowledge, sir.
Okay. Well, let me go then to the second part of my question, and that is We then go to the states having their statutory periods, generally 2 years, as has been pointed out, for review. But, Mr. Ham, you pointed out that under your policies, I believe you said that you give the potential customer 10 days to review the application and to notify the company of any errors, and 10 days to just say we don't want to have the policy in effect. Are there any states that currently have in place a period of time for insurance companies to mandatorily review for these kinds of misstatements? In other words, review the medical records within a given time other than the 2-year period. Do any states have a shorter time frame?
I'm not aware of that. We comply with all applicable state statutes, and in, I think it's almost all states, we have a 10-day free look where we send the customer a copy of their application, remind them that they are attesting to the accuracy of it, ask them if they have any questions or changes, and then as part of the policy and the welcome letter, we reinforce the importance that we receive all the disclosed information appropriately.
If, though, something was going to be rejected based on information that was in an application or information in medical records that were either, for whatever reason, not disclosed, it seems to me that 2 years is a rather lengthy period of time. And in practical application, it seems that even in that 2-year period, it takes some other triggering mechanism to institute the review, that there is no normally dictated review of the applications unless something triggers it or brings it to your attention. Should there be a time frame shorter than this 2-year period, and should there be a review that takes place prior to a triggering act taking place?
Let me clarify that we do not post claims underwrite. We ask information of every single applicant to the company, and 80% of the time we receive additional information from them, and we ask them to fully disclose all their information. It's only when we're aware subsequently that there was some information that was omitted or inaccurate that we would investigate whether a rescission should be made.
But that would be that triggering act. And you wouldn't know about that unless something by way of a pharmaceutical being prescribed or an office visit in the doctor's office or a hospitalization.
That is correct.
What I'm asking is, just as you give the policyholder 10 days to review the application to figure out if it's correct, should there be a comparable, maybe longer, obviously I think longer, period of time in which the company, without some triggering act, should be required to review the applications and say, hey, we think there's something wrong, or ask for additional information, rather than waiting until people get in a posture where they probably are uninsurable at the time the issue is raised?
Something to discuss and give some thought to.
Thank you, Mr. Chairman.
Mr. Burgess for questions.
Thank you, Mr. Chairman. And that's last point of Mr. Deals, I think, is an excellent one, and likely would have eliminated the problem for at least one of the 3 witnesses that we had in front of us this morning. But let me just ask Mr. Ham, Mr. Collins, Mr. Sasse, after you were here and you heard the testimony this morning of the 3 individuals who testified, what do you think after hearing that? Is that something that and again, I'm coming from the perspective of someone who supports the individual insurance market. I was a customer of the individual insurance market at one time. I may be again in the future. I recognize the value that you bring, and I want you to be able to continue to do the type of business that you do. But you heard the comments, the opening comments of the chairman of the subcommittee this morning. There is a move afoot to do things in a way that would be very difficult for you to do business in the future. And I, for one, would not like to see that happen. But tell me what your impressions are after hearing the testimony that you heard this morning.
I'd be glad to respond to that, Congressman, and I have to say I really felt bad. You know, I have a lot of empathy for the people that are impacted, and I know in my own life I've dealt with the cancer, and I just have a lot of empathy and concern for the people, and it's my hope that there'll be changes made, that this will no longer be necessary. It's just that today, when we have a voluntary system of insurance where people choose, we have to collect information up front to underwrite, And if we didn't have that process, then people would wait until they had a health condition before applying for coverage, and the rates would be much, much, much higher than they are today. I chaired the group within AHIP that put forth reform proposals, and in our proposal, we suggest that the country should move towards a guarantee issue environment with no pre-existing conditions being excluded, as long as everyone is required to participate.
Let me
and
ask
if
you a
everyone participates,
Yeah,
then there is no need for rescission, and the price need
all right.
not increase for those currently covered.
You've brought that up. What do you do with a segment of society that's just not going to participate? I mean, there will be, that segment of society will exist, whether it's the individuals who are in this country without the benefit of Social Security number, whatever that number is, 10 million, 12 million. People who just don't comply. We live in a free country and they don't like mandates. Look at the people who don't comply with the mandate of the IRS right now, knowing the penalties that are out there waiting for them if they get caught. So people are perfectly willing to fly beneath the radar. What then? Will these people be rated on whether or not they had a pre-existing condition, or are they just absorbed then by the larger tax-paying public who does play by the rules and pays their bills on time?
We believe that the requirement to purchase insurance should be enforced. We believe that those that don't have the means should be subsidized, and we would look forward to working with Congress to find a solution that's workable for all Americans. But I believe every American must have access to high-quality health care. We have to work together to find out how we can make that happen.
Well, you and I will fundamentally disagree on that point, and I think the approach that was taken by Congress in the development of the Part D program in Medicare, for all of the faults initially rolling it out, creating programs that people actually want, that are actually useful for people, will be a better way of going about that. The coverage rates for prescription drugs amongst seniors now in excess of 90% with a very high satisfaction rate. And clearly, in my mind at least, that is a better strategy than simply layering another mandate on the American people or the employers of America. But I don't disagree with you that something needs to happen, and let me just take this to a different level, and again, I want to pose this question to all three, and I really would like an answer from all three on this. If there were a system of universal coverage without government intervention in the marketplace, is there a better way to accomplish our goal of universal coverage without that excess market manipulation by the government? Insurance companies have used adverse selection methods to deny or cancel policies in the individual market. Apparently it happens also in other markets. To the extent that this has been allowed in law, the business interests almost dictate those actions. Yet some of us have argued that if we let the market work, you could make an innovative product for all. So here's my question. Will you today publicly and clearly commit right now that regardless of what happens in Washington, whatever decision that we reach on health reform, that you will design a product for all populations, regardless of claims history, but also economic status? And I would like an answer to those questions individually. A product for all populations regardless of claims history, and all populations regardless of economic status. Would Mr. Hamlin, why don't you go first, and then we'll just go down the row.
I'm having a little difficulty following your question, sir. If I may understand specifically what you're asking.
Regardless of what we do, whether we do an individual or business mandate, employer mandate, maybe we don't do a mandate at all, but you have it within your power to design a product so that all populations, regardless of claims history, could be covered. Would you be willing to do that?
In the current system, that would not be feasible. We need to have an environment where all Americans are required to participate before we could give those assurances.
So you would not be willing to alter business practices if there were a way to do that, to provide coverage for a greater segment of the population, even with a claims history?
If the reforms proposed by AHIP and are adopted, then we'd be very glad to participate in the system, but it is necessary that all people participate. When it's a system where people choose, we need to have the process of assessing risk at the time of the application.
With all respect, the reforms proposed by AHIP are not going to happen. You are going to get a plan as your chairman outlined here this morning. Mr. Collins, can I get you to answer briefly? Would you be willing to design such a product?
Briefly, we're going to have votes here quick.
Sir, would respectfully have to agree with Mr. Ham that a guarantee issue product that would fit all people at an affordable price is economically practically impossible. What I would suggest is that HIPAA also creates alternative coverage mechanisms for each and every state. So each state's supposed to have a high-risk pool or an alternative coverage mechanism, and these high-risk pools have been woefully underfunded. So one of the things that could be done right now today is to increase the amount of funding going into those high-risk pools so that people that have those serious health issues and are otherwise uninsurable in the individual market have a place to go that's affordable and affords them the care that they need.
And on the issue of high-risk pools, I think the private sector is going to be required to make a contribution to that as well, and that you all in the private sector, whether it be group insurance or individual market, there must be a product that is available to everyone regardless of their claims history. Yes, they may require federal subsidy. Yes, they may require state subsidy. And yes, the private sector may have to bring something to the table as well. Mr. Sassy, let me ask you.
All right, that's it. Last question, Mr. Burgess. You're just going on. Go ahead.
Let me ask you then just to answer the
Last
question that I
one.
posed to the other. Regardless of the claims history in the population, would you be willing to make a product available?
I have to agree with my colleagues here that in the current voluntary individual market, we could not guarantee issue policies where people could jump in and out of the insurance market. We have had experience of states that have implemented guarantee issue without an effective enforceable personal coverage mandate. And unfortunately, that has resulted in significant cost increases that have to be borne by others in the individual market. So the answer would be no.
Mr. Chairman, you've been very generous with your time. Again, I would just stress that this is going to take creative thinking outside the box. I don't think you're going to get what you want in the AHIP proposal. You're going to get more something that looks like what the chairman outlined to you at the beginning. And I would urge you to think creatively about this problem, because this is the difficulty that leads us to where we are here today. And I can't help you.
Okay, questions or speeches are over.
If you're not willing to move on this issue. And thank you, Mr. Chairman. I'll yield back.
We hope the chairman's, not my plan, but our side plan does work. We do hope that. I won't argue it with you now. That's for another hearing. Let me ask another one, and we can maybe get in around there. We're going to have votes here in a few minutes. Now, each of you provided to the committee information that relates to certain medical conditions that automatically triggers an investigation into possible grounds of rescission. Mr. Sassy, I left off with you. You had 1,400 different conditions that automatically triggers an investigation. Mr. Ham, on behalf of Assurant, there are 2,000 conditions that trigger an investigation that you provide to the committee. These include breast cancer, ovarian cancer, and brain cancer. Why does cancer trigger an investigation?
What triggers the investigation?
No, why does cancer trigger an investigation?
I will answer. What triggers the investigation are the types of medical conditions of a chronic nature where there's a high probability that the condition would have pre-existed at the time of the application. It is not based on the cost of the claim. It's based on the medical condition. In fact, the people that make the rescission decision are not aware of the cost of claim. It's all about
if it's the medical conditions, if it's the medical condition, then before you sign them up, why don't you get all the medical records? Why don't you find it then? Why do you wait until there's a claim?
If we were to receive all the medical records at the time of application, that would delay the process significantly, delaying people's access to health care, and it would add a tremendous amount of cost to the product. The vast majority of applicants provide all the information that's asked for at the time of application.
So it's a cost issue. It's too costly to get the medical records.
It would add to the, yes, it would add to the premiums that our customers would pay by a significant amount.
So does it cost $40 to get medical records?
I'm not familiar with the cost, but it would also delay the process.
But wouldn't it be better to delay the process to make sure a person's insured as opposed to pulling them when they're going through cancer like Mr. Raditz?
The vast majority of our customers provide the appropriate information.
So did Mr. Raditz, but you still denied him coverage, right?
I unfortunately cannot comment on that particular case.
Well, Mr. Collins, in asking the same question of United, you insisted that you also use a computerized system to identify cases to automatically investigate for possible rescission. But there was no one at your company who knew how the computer decides which files should be reviewed. So is it the case that United has put the decision of which patients will have their health care treatment interrupted by a rescission investigation in the hands of a computer that no one understands?
No, sir, that is not true. I haven't really been privy to the discussions between my staff and your staff on this issue. We've been trying to come to an understanding about how to best provide the data in a format that's easily understandable. But let me just say,
Can you tell us what conditions the
process,
computer considers for a possible rescission investigation?
No single factor is used in our process to trigger an investigation. So we look at the system looks as it's screening claims that come in at the effective date of the policy, the effective date of the procedure, the severity, the type of service, and the diagnosis code. Those are all factors that go into the algorithm that pulls cases out for screening.
Well, the algorithm, no one from your company could tell us. Will you commit to us today to produce whatever witnesses or documents are necessary to explain your algorithm, your computer selection process? Could you do that? Will you commit to do that for us?
Yes, sir. We are.
We're still trying to figure it out.
We are trying to put it in a format that would be acceptable to the committee, sir.
Dr. Politz, Professor Politz, do you see a common thread here among the conditions? I mean, you got 1,400 conditions, 2,000 conditions in the computer that it can't explain that does rescission. Why do you think they have all these rescissions?
I think the common thread is that if somebody makes a claim for anything serious in their first year, there is an opportunity to go back and review the entire transaction to see if it's going to be withdrawn. I think that's just the common transaction. And I think it is not consistent with your federal law. And whatever else you may do going forward.
But as to the HIPAA law, basically we leave it up to the states, and then HIPAA has to be enforced by the federal government, CMS, right?
That is correct. The ultimate enforcement.
So the value of the law only depends on the enforcement of the law.
Yes, it does. And there is a fine of $100 per day per affected individual for noncompliance with the law that can be levied.
Let me ask each of our CEOs this question, starting with you, Mr. Ham. Would you commit today that your company will never rescind another policy unless there was intentional fraudulent misrepresentation in the application?
I would not commit to that.
How about you, Mr. Collins? Would you commit to not to rescind any policy unless there's an intentional fraudulent misrepresentation?
No, sir. We follow the state laws and regulations, and we would not stipulate to that. That's not consistent with each state's laws.
How about you, Mr. Sassy? Would you commit that your company will never rescind another policy unless there was an intentional fraud misrepresentation?
No, I can't commit to that. The intentional standard is not the law of the land in the majority of states.
What do you think? It's fair to rescind somebody for an innocent mistake?
Well, I think applying a knowing standard is a much more objective and
Well, our first panel, none of them
apply.
had any knowledge of it, and they were all rescinded, right?
I'm sorry.
Our first panel, none of them knowingly made a misrepresentation, but they were all rescinded. Their policies from Ms. Baton all the way down to our witnesses there. There weren't material misrepresentations, right?
It's our policy, if we determine that the applicant did not know about a specific condition, we would not rescind.
Okay. So like Ms. Horton there, you wouldn't have rescinded her, but
I can't speak to the specifics of Ms. Horton's case. I am not familiar with the specifics. I'm sorry.
Mr. Barton, Mr. Barton for questions, please.
Thank you. Well, I want to thank our witnesses for being here. This is a difficult situation, but I listened when y'all answered Chairman Stupak's question about unintentional omissions, and to your credit, you were honest that you would reserve the right to still rescind some of these policies. Doesn't it bother you that people are going to die because you insist on reviewing a policy that somebody took out in good faith and forgot to tell you that they were being treated for acne? Doesn't that bother you?
Yes, sir, it does. And we regret the necessity that that has to occur even a single time. And we've made suggestions that would reform the system such that that would no longer be needed.
Well, you know, I haven't heard your opening statements. I glanced at them, and I haven't heard the first round of questions, we understand the need to verify that people are telling the truth. We're not asking you guys, the insurance industry, to automatically take somebody's word for it. I mean, I understand that. But when I see advertisement after advertisement about be a part of the family and, you know, we treat you like our, you know, our own family, and then somebody who doesn't have group coverage takes out an individual policy and runs into some situation where they have a health care issue that requires a major claim early in the policy, if they operate in good faith in taking out the policy and you approve them, I really don't think it's good business practice to go back and try to figure out a way to rescind that policy. If nothing else, it's a false trade act, false trade practice, truth in advertising. And one of the beauties of our Constitution is a little thing called federal preemption. We have the authority on this committee to preempt state law if it's in interstate commerce. Now, we can't preempt state law in intra-state commerce, but we can in interstate commerce. And I don't think there's one vote on this committee for the practice of retroactively reviewing a policy to try to rescind it. If you have a woman like my constituent, Ms. Baton, who discovers that she's got breast cancer, or you have somebody who needs a stem cell transplant, or even the young lady from California who just needed some blood work done. I mean, we'll back you up on fraud and misrepresentation, but I don't think you're going to get a vote at all on rescissions that are not material to the claim being processed. I don't know that that's a question. That's just a statement. So if you'd like to comment on that, I'd certainly like to give you the opportunity to do it.
No one cares to answer?
I would just reinforce that rescission would only occur when the information was material to the initial, if the information was material to the underwriting decision. Only in that case.
Well, Mr. Chairman, I'm going to yield back. I mean, I would assume.
Okay, could I follow up on that?
Sure.
Well, if it's material to the representation, let me ask you this. In your policy, Mr. Ham, it states in question number 14 on your questionnaire, your enrollment questionnaire. Now, tell me how you get a misrepresentation. Within the last 10 years, this is what it says, because you said your assurance health enrollment questionnaires are simple, easy to understand, straightforward language, so people can easily and accurately report their medical history. So, your question says, within the last 10 years, has any proposed insured had any diagnosis, received treatment for, or consulted with a physician concerning phlebitis, TIA, cystitis, lymphadenopathy, or glandular disorder? So tell me, what is TIA?
I am not aware. I believe.
How would if you don't know what it is, how would anyone filling out your application know what it is? So there's grounds to deny them right there. You don't even know what it is, either do I. How about phlebitis or lymphadenopathy? How about lymphadenopathy? What's that?
I don't know the answer to those questions.
Do you sincerely believe that an average applicant would know what these words mean if you don't know and I don't know?
Sir, I believe that is an application that is not currently used at this time. I would like to
It's last year's application. Last year's application, and your, yeah, it's last year's application. Have you changed the application last year?
I'm sorry, sir, I didn't hear.
That's last year's application. Did you change it in the last year?
I'm not aware if we have changed that application.
So, as far as you know, that's your current application.
But I believe that our current applications in most state ask questions back to 5 years. So the The 10-year might be different than what we issue today. I would need to.
What's the
look
same
into that and
questions,
get back.
PIA, right, that you don't know what it is, and,
I do not know what that is.
okay. Mr. Deal?
Mr. Chairman, I do have one
Sure,
question.
sure, Mr. Barton, I took your time, I'll
This,
yield
this,
you to
is
go
a,
to Mr.
this is
Barton.
a hypothetical, but I just want to figure out what the answer is. I had a mild heart attack 3 years ago. So I now take 6 different medications every day, and I'm going to probably have to take those medications for the rest of my life. I'm covered under a group plan, Blue Cross Blue Shield of Texas, that's available to every federal employee who lives in Texas. And my coverage has been good. I've never had a problem. But let's say I quit the Congress, and I go into business for myself, and I try to get a private health plan like Ms. Baton got when she switched jobs from being a nurse and went into business for herself. On the application, I have to list the medications that I'm taking, the fact that I had a heart attack, give the doctor the time, the location. But I broke my leg playing football in high school. I got a 250-pound fullback, ran over a 150-pound linebacker. I was the linebacker. Now, if I forget to put on my application with your companies that I had the small bone in my left leg broken playing football in 1967, but I do put all my medications and my history of my heart attack, the fact that I omitted breaking my leg in 1967, is that a grounds to rescind my claim, my policy later on? Under your policies right now that your companies issue. I admit to my big problem, tell you the medications, all the stuff, but I just flat forget that I broke my leg and was treated for a doctor paid by the Waco Independent School District in 1967.
Congressman Martin, our underwriting guidelines really kind of dictate that, but it's my understanding of how our underwriting guidelines work is that since that condition would not be material in our initial underwriting decision because it happened so far in the past and was of a non-serious nature, that would not have factored in to the underwriting.
And I understand you might not cover me because of my heart attack. Right. I understand that. It'd be totally within your company's right to say, Congressman Barton had a heart attack in 2004 or 2005, therefore we can't issue him a policy. I understand that. My question is really about my leg injury from way back when. If I don't disclose that, does that disqualify me potentially on down the road? Mr. Collins?
Sir, the application's looking for information going 10 years back, so that would
not be material?
That would not be material.
Okay, Mr. Ham?
The same answer as Mr. Collins.
Okay. Thank you, Mr. Chairman.
Mr. Dio for questions, please.
Thank you, Mr. Chairman. We are talking here in the private insurance market, and I believe, Mr. Sassy, you said that's somewhere in the 15 million range. Is that correct? Correct. To you three gentlemen, do you also have policies that extend to ERISA-type coverage plans? Do all three of you?
Yes. WellPoint insures 1 in 9 Americans. The vast majority of our members are covered under ERISA plans.
Mr. Collins?
Yes, sir. The majority of our membership are also in group insurance plans, which are covered under ERISA.
Mr. Ham?
The majority of our policies are individual. However, we do have some customers that are under ERISA.
Does the same problem pertain in the ERISA marketplace as in this private insurance marketplace? Ms. Polish, you indicated you think it does.
There is rescission in the
I'm sorry, I can't hear you.
There is rescission in the small group market. It operates a little bit differently because that is a guaranteed issue market. But a similar process, if a claim is submitted during the pre-X period, it is largely the eligibility of the members of the group and the family members of the group that will be reinvestigated to see if there's any way that the people who made the claim shouldn't have been on that policy in the first place.
But the state periods like 2 years do not apply because it's an ERISA plan.
Well, your pre-X rules are also much tighter in the small group market. So Congress has said that these questions about 10 years ago, 5 years ago, those don't matter in the small group market. You're only allowed to apply, an insurer is only allowed to apply a pre-existing condition for something that was actually treated or diagnosed in the 6-month window prior to coverage taking effect. So anything that happened before that isn't even allowed to be considered. And if the person coming into the policy had prior group coverage, that gets credited against the pre-X, so that can't be considered either. So it is mostly eligibility.
Okay.
And I've
I'm
seen
going to try to be real
stepchildren
quick
and
here,
stuff get taken.
and I apologize for cutting you off. With regard to what needs to be done, in the event we don't get the major reform that y'all have been talking about, anybody else is talking about, in the event it becomes something of trying to narrow a time window in which insurance companies have the right to review medical records, would it not be feasible that if we had electronic medical records, that would facilitate a more timely review? I would assume common sense would say that it would. Ms. Paulus, do you foresee that consumer protection groups would oppose making those kind of personal medical records available for insurance companies to review in a timely fashion so that we would not hopefully have these situations to develop?
They're already available for review.
Well, we don't have the extent of electronic medical records that we all hope we will have.
But the privacy rules that you have in force today under HIPAA say that medical underwriting is a permissible reason for disclosure of medical records.
You would see no reason that anybody would raise that issue.
It's already permitted under current law.
The last thing, and this is more of a comment than anything else, I think the issue that Dr. Burgess discussed with you about those who are now being excluded because of pre-existing conditions, et cetera, I think we all know that our high-risk pools have not effectively operated and certainly not existent in states, some like mine, for example. I think we need to be looking at a policy where we would maybe take those funds that are available for high-risk pools, some of which are not being utilized, put them into an environment in which we could, perhaps with the sharing of some of those costs with the insurance industry, bring these individuals into the pool with the additional revenue that would be available from federal sources. I just simply suggest that something we all need to be thinking about, in my opinion. Thank you, Mr. Chairman. I yield back.
Mr. Burgess, you want to question now, or do you want to come back after votes? We only got 5 minutes, so I'm going to have to hold you tight.
Okay, you know me, I can be really brief.
I've never seen it yet, but go ahead if you want to try.
Well, just ask you, all three of you briefly, well, you know, you've heard the discussion of the public option plan. What's your opinion of that?
I oppose a public plan option.
Mr. Collins?
Sir, I believe that with the reforms that have been proposed, that we can make the market work much better without a public plan.
And Mr. Sassy?
We also oppose the public plan. We also feel that
Well, I don't want to be the one to have to break this to you, but the reality is you're very likely to get a public plan. You are not likely to get the deal that was struck by AHIP down at the White House. I mean, I think you can see the handwriting on the wall. I would urge you to think outside the box on this one. There are ways that we can solve this problem without going to a public plan, in my opinion, and without leaving so many people uninsured and without leaving so many people that fall through the cracks as we heard this morning. Clearly, the situation as it stands right now is unstable. It's untenable. We can't continue it. But you guys have got to be able to come to the table with some innovative thinking on how we provide coverage to that segment of the population that is particularly vulnerable and needs the coverage. We don't need to turn the whole system on its head just to cover that 10 or 15% that is right now left out. But that's what we're going to do if you don't help us with this. And the fallback position, I promise you, is a government-run plan, and that's what you're going to get if we don't work together on this issue. So I appreciate you all being here today, Mr. Chairman. I appreciate the extra time, and I'm going to yield back.
Okay, so you didn't have a question on the subject of today's hearing. Okay, lecture, okay. In all fairness, the well point there, I said in my opening statement, and if you care to comment, please do. I said in my opening statement in the committee investigation, WellPoint evaluated employee performance based in part on the amount of money its employees saved the company through retroactive rescissions of health insurance policies. According to the documents obtained by committee, one WellPoint official was awarded a perfect score of 5 for exceptional performance based on having saved the company nearly $10 million through rescissions. Do you care to comment on that? I think it's fair to give you an opportunity to comment on it.
Thank you, Chairman. During the process of collecting information requested by this committee, we did uncover 2 performance appraisals from 2003 that were isolated to one area within California that included one line each, referring to retro savings and a dollar amount. They were in the context of a part of the performance appraisal with other metrics, and they were part of a more comprehensive performance appraisal that was, I think, 5 to 7 pages long. I reiterate my statement that WellPoint does not have a policy. It is not it has not been our policy to systematically reward associates for performing rescissions, for tracking the number of rescissions, or the dollar amount.
But didn't both of those employees receive bonuses somewhere between 600 to about 6,000, I think the range was?
My understanding is that those associates received within the average compensation that all WellPoint associates received for that given time period.
Okay, so it's not the reviewers, all your employees.
Right.
Okay. With your profits, I guess you could give bonuses. All right, that concludes our hearing for today. The committee rules provide that members have 10 days to submit additional questions for the record. I've already had the record books already been submitted for the record. We'll redact any business proprietary or anything that relates to privacy concerns or is law enforcement sensitive, so that will be entered into the record. That concludes our hearing. I thank all of our witnesses for coming, and that concludes this subcommittee hearing.